Have you seen this movie, Special 26? Even if you have not, just remember Chapter 12 is about police and their functioning. This chapter is important from police departmental exam and police competition as well. We are going to cover CRPC section 154 to 176. Total 26 section. Few additional that was added on its amendment. From where does it begin? Definitely, when someone complains to the police regarding some crime, it is considered as first information and it is registered as first information report, that is FIR. If the information is relating to cognizable cases, it comes under section 154, and non-cognizable cases, it comes under section 155. After the complaint, the police has the power to investigate. In cognizable cases, it is under section 156 to section 159. To begin with, section 156 says the police has the power to investigate in cognizable cases, and subsection 3 of 156 also says that any magistrate empowered under section 190 of the Criminal Procedure Code may order investigation in cognizable cases on a complaint if the police does not register FIR. After the complaint has been registered, section 157 says the IO, investigation officer, shall proceed to the spot to investigate the case, and after his investigation, section 158 says he will submit the report to his senior or to the magistrate if the investigation has been ordered by the magistrate. When such preliminary investigation report is given to the magistrate under section 158, the magistrate will check the report and can order further investigation in the case if not satisfied. Next, section 160 says that police will give notice for investigation but will not call the females to the police station, will not call the senior citizens to the police station, and not less than 15 years or sick infirm people. These exceptions were added in 2013 amendment. After calling witnesses by police under section 160, section 161 says police will examine witness and take their statement. They can record the statement by audio or video mode, and this was inserted by subsection 3 of section 161. The amendment was done in 2008. Next, section 162 says witnesses will not be asked to sign the statement that they have given to the police. Next is section 163. It says witnesses will not be given threats or promise to give statements. And section 164 says that recording of witnesses' statement or confession will be done. Recording of statement was said under section 161 as well. Well, it was by police and inadmissible, but this is before magistrate and admissible. Next, in the 2005 amendment, section 164A was added about the medical examination of a victim of rape. Now comes section 165. It says search by police. This search is done as per the provision given under section 100. Remember that we have already covered in chapter 7 of Criminal Procedure Code 1973. Now don't be confused this section with section 156. 156 regarding police power to investigate in cognizable cases, and this is regarding their search. Next is section 166. Search outside the police station. Well, they have their rules, but not this serious. Anyway, 166A says search outside India. 166B says search in India by foreign countries. Section 166A and B were added in 1990 Amendment Act. Next is Section 167. It says when investigation cannot be completed within 24 hours, they will have to release the person if arrested. Now, this rule of time frame is given under Section 57 if you remember. Next, Section 168. It says if the investigation is done by the subordinate police officer, he shall report it to officer in charge of the police station regarding such investigation done by him. Now, if the report under Section 168 of the police officer says no sufficient evidence or reasonable ground of suspicion for forwarding the accused to the magistrate, then Section 169 gives power to the police to release the person from custody with or without sureties. On other hand, Section 170 is opposite of 169. It says if there is sufficient evidence or there is reasonable ground of suspicion, the officer in charge shall forward the accused under custody to magistrate. Next, Section 171 says complainant or witnesses are free to attend court on their own, but if they refuse to attend court, then they can be arrested. Now, for all such procedures, the police has to prepare a case diary. This is what Section 172 says, to prepare a CD. It's also called a special diary, police diary, or a station house diary. Now comes a Section 173. It's final report of police, also called as challan or charge sheet. Section 173 was amended in 2008. Section 1A was added regarding child rape, custodial rape. Section 173 was again amended in 2013. Section 2H was added regarding medical report of women. Next is Section 174. It is on inquest reports, also known as Panchnama. The report is prepared upon unnatural deaths, suicide cases. Well, now in Chapter 12, how many police reports did you note that comes under the preview of Section 154 to Section 176? Think about it. There are four kinds of reports prepared. Number 1, Section 157 says the preliminary report. Number 2, Section 168 says the report that is given to senior. Number 3, Section 173, it is the final, the challan. And number 4, under Section 174, the inquest report. Now comes Section 175. It gives power to the police to summon witnesses, and Section 176 gives power to the magistrate to inquiry into the cause of death, disappearance of a person or rape of a woman in police custody. Watch this lecture once for next 5 days and you will be surprised to know that you have learned all the sections by heart. Learn all the sections of Chapter 12 by heart. Well, let's make it easy. Imagine yourself as a police officer. Now, think as a police officer. First step, if someone informs you about a crime, you have to register FIR under Section 154 if it is regarding cognizable offences. You have to write an FIR under Section 155 if the information is regarding non-cognizable offences. Then you as a police officer has the power to investigate under Section 156. How are you gonna investigate? The procedure is given under Section 157. And then you have to submit the report. Section 158 says submit a report of your investigation to your police officer or magistrate if the inquiry was ordered by the magistrate. Section 159 is not for the police but the magistrate to order further investigation on such report. You as a police officer has also the power to call the witnesses to the police station under section 160 for investigation except the women, senior citizen, children below 15 years, sick and infirm people. And section 161 says how will you examine the witnesses. On other hand, section 162 says you will not ask them to sign the statement. The police officer will not ask to sign the statement. And please be a good police officer. This is what section 163 says. Don't threaten them to give any kind of statement. Next, section 164 is again for the magistrate to record the statement or confession. Now, after the statement has been taken, police officer G, what are you going to do? Definitely, you're going to search for stolen things, item, weapon used in the crime, search for the people, search for evidences. That is what section 165 says. And if the search is outside your police jurisdiction, 166 will guide you. On other hand, if you are not able to do the search within 24 hours, the time frame of 24 hours is given under section 167 and 168 says regarding your search report to your seniors. If you have found no evidence in your search, 169 says you have to release the accused. On other hand, if you found the evidence in search, 170 says send the accused to the magistrate. And section 171 says you have the power to arrest the complainant or the witnesses if they refuse to attend the court. And remember, you have to prepare a case diary, CD, for all such things. This is what section 172 reminds you. And finally, you will prepare a final report that is called challan. And if it is an inquest inquiry, that is unnatural death, that you will give under section 174. 175 give you power to summon witnesses for inquiry under unnatural death cases. And the last section, section 176, this is the power of the magistrate to inquiry into the cause of death or a rape on a woman. Now let's cover all the sections of chapter 12, information to the police and their power to investigate. You will find it easy now. First section 154, clause 1. When information in cognizable offences is given orally to officer in charge of police station, it shall be reduced in writing and signed by the complainant. Obviously, the person who is complaining will sign it and will be kept as state government gives the instruction. However, an offences under 326 A and B, offences under 354 A, B, C, D, offences under 376 A, B, C, D and E, or section 509 of IPC. These offences either committed or attempted. Such information shall be recorded by woman police officer or any other woman officer only. This was inserted by 2013 amendment. Now further, it says that the offences committed under section 354 A, B, C or D or under section 376 A, B, C, D and E or offences under section 509 of IPC. Either the offense has been committed or attempted if it has been on a person who is temporarily or permanently mentally or physically disabled. Such recording by the police officer will be done at the residence of the person seeking to report or at any convenient place of the person's choice. Number 2, in the presence of an interpreter or special educator as the case may be. It further says that such complaint will be videographed and the police officer shall get the statement of the person recorded by a judicial magistrate as soon as possible. Subsection 2 of 154 says that copy of the information which is given by the informant will be given by free of cost. Subsection 3 of section 154. This is very important. If the police does not register your complaint, refuses to write an FIR, the information or the complaint letter can be sent by post to SP, Superintendent of Police, concerned of that area. And if he is satisfied either by himself or he may instruct his subordinate to do the investigation only in cognizable cases, cognizable offenses. Second point, information as to non-cognizable cases and investigation on such cases as per the provision of section 155. Subsection 1 of section 155 says that when an information is received in a police station and that information relates to a non-cognizable offense, it shall be noted down in the book. This is as per the instruction of the state government. Subsection 2 of section 155 says the police officer shall not investigate a non-cognizable case without the order of the magistrate. This is a very important question. It might come in judicial exam. Subsection 3 of section 155 says the police officer will investigate when he is given the instruction from the magistrate. He has all the powers, but he does not have the power to arrest without a warrant. Subsection 4 of section 155 clarifies the confusion in a situation when an information is given to a police that relates to two or more offenses and one offense is cognizable, other is non-cognizable, then the case will be deemed to be a cognizable offense. Third point, police officers' power to investigate cognizable case as per the provision of section 156. Subsection 1 of section 156 says police has the power to investigate in cognizable cases without the order of the magistrate. In an important case of S.N. Sharma versus Bipin Kumar Tiwari, AIR 1970, Supreme Court 196, it was held that magistrate cannot prevent the police from investigating. It is in subsection 2 of section 156 which says that no one will question as to the investigation done by the police regarding his powers. And subsection 3 of section 156, this is very important. I repeat, subsection 3 of section 156, it empowers the magistrate under section 190 that he can order an investigation to a case when he receives any complaint or when he sees it himself. In Bateshwar Singh versus State, 1992, Criminal Law Journal 2122, this is the case of Patna. It was held in this case that any magistrate refers to judicial magistrate, not the executive magistrate. So only judicial magistrate can order investigation into a case. After the FIR under section 154 and 155 and the police, and then the power of the police to investigate under section 156, now we come to section 157 as to the procedure of investigation by the police. Subsection 1 of section 157 says on information, that is FIR, the police has the power to investigate as said under section 156 and shall give report to magistrate. It's called the preliminary report on complaint received, and the police officer shall either himself or depute his subordinate. This is as per the procedure prescribed by the state government, and will proceed to the spot to investigate the facts and circumstances of the case, and if necessary will take measures for the discovery and arrest of the offender. Now let's take up an important case. State of Jammu and Kashmir versus Mohan Singh, 2006, Criminal Law Journal 169, Supreme Court. In this case, FIR was recorded in the evening, but the copy of the same was not sent to magistrate at his residence during the night. However, it was sent at the earliest on the next day in court. It was held that it cannot be considered that there was delay in sending a copy of report to the magistrate. Now let's cover the two things that subsection 1 provides us. A. If case is not of serious nature, the police officer need not proceed to spot for investigation. And second thing, B. If the police officer considers investigation is not required, it is his discretion not to investigate the case. He is not bound to act on the information. Well, this is sometimes creates a problem. We want them to investigate and they refuse it because of this clause. Anyway, Further, subsection 1 of section 157 provides that in case of a rape offense, the statement of the victim can be recorded at place of her choice and by a woman police officer, obviously in presence of her relative, guardian or a social worker of the locality. And don't forget an important question on it. This was added in 2008 Amendment Act. Now we come to subsection 2 of section 157. It only informs us that in clause A and clause B of subsection 1 of section 157, if a police officer decides that he does not want to investigate, he will give the reasons in writing. And this is as per the procedure stated by the state government of that area. That's it. After knowing the procedure, we come to fifth point, report how submitted as per the provision of section 158. Subsection 1 of section 158 says if the state government gives order, general or specific orders, then the report of the police under section 157 should be submitted by superior officer of police. And subsection 2 of section 158 simply informs us that the superior officer on such orders that is given under subsection 1 will instruct to officer in charge of police station, and after recording instructions on the report will submit or transmit the same without delay to the magistrate. That's it. After the preliminary report prepared under section 157 and submitted under section 158, now comes the sixth point, which is the power to hold investigation on preliminary inquiry under section 159. Section 159 informs us that when magistrate receives such a report of police on a complaint, he has the power to direct an investigation, or he can ask his subordinate magistrate two things: 1. To hold preliminary inquiry, 2. To dispose of the case, if the inquiry or the investigation is not required. Let's understand section through an important case. S.N. Sharma versus Bipin Kumar, AIR 1970, Supreme Court 786. It was held that section 159 is preliminary, meant to give to the magistrate the power of directing an investigation in a case where the police decides not to investigate the case under the proviso of subsection 1 of section 157. So this is an important case which informs us that magistrate can order an inquiry only when the police refuses to do so, and that power of the police to refuse is given under subsection 1 of section 157. Seventh point, it is the power of the police to require the attendance of witnesses as per the provision of section 160. Precisely, subsection 1 of section 160 says that the police officer has the power for investigation purposes to require attendance before him any person within the limits of his police station or the adjoining police station. What is the purpose of police requiring the attendance of witnesses? To know the facts and circumstances of the case. Let's understand it better through the case of Narayan Swamy versus Emperor. It was held in this case that the word any person includes a person who may become the accused. Now when we read the section, it says the police power to require attendance of witnesses, and someone can say it is only for witnesses, not the accused. But in Narayan Swamy versus Emperor, it was clearly held even the accused can be called for, and the purpose will be only for knowing the facts and circumstances of the case. This was better explained in Another case, State versus NMT Joy Immaculate, 2004, Criminal Law Journal, 2515, Supreme Court. In this case, it was held that the section applies only to possible witnesses in the trial or inquiry. An order under this section cannot be made by the police requiring attendance of the accused person with a view to answering the charge against him. The accused cannot be examined as a witness either for or against him. So the police can require the attendance only to know the facts and circumstances of the case. That's it. Anyway, it is further provided under subsection 1 of section 160 that no male person under the age of 15 years or above the age of 65 years will be called to attend any place other than the place in which such male person of less than 15 years or above 65 years resides. Also not a woman, also not a mentally or physically disabled person. This was added in 2013 Amendment Act. Now comes the subsection 2 of section 160. This is very funny. The state government may, by rules made in this behalf, provide for the payment by the police officer of the reasonable expenses of every person attending under subsection 1 at any place other than his residence. I think you will also find it funny that police is going to pay. I repeat that the police is going to pay the amount which the state government may fix to give to such people who are attending such inquiry which the police officer is asking them to come at any spot under subsection 1 of section 160. Basically, they are trying to say that since you are helping the government, since you are helping in the case for giving facts and circumstances, basically the traveling expenses from your residence to the spot where the police is requiring the witness or the accused to come and help the police in investigating their case. Examination of witnesses by police as per the provision of section 161. Subsection 1 of section 161 says, police officer will examine the witness orally who is acquainted with the facts and circumstances of the case. Acquainted means a person known or who is aware of the case. Subsection 2 of section 161 says, such person, that is the witness of the accused who is called for examination by police, shall be bound to answer truly in relation to the case, except, here's the condition, except the answer to those questions, the answer that could expose them. It means subsection 2 of section 161 says, not to give statement against himself for any criminal charge or to penalty or forfeiture. Subsection 3 of section 161 says the police asking or examining the person orally as stated under subsection 1 of section 161. Now in subsection 3 of section 161 it says that the police officer asking such things orally will reduce that into writing, means he will note it down everything. In subsection 3 of section 161 it was added that such statement can be recorded by audio, video, electronic modes. This was added in 2008 Amendment Act. It was further added in this thing in 2008 Amendment that the statement of a woman whom an offense under 354A, B, C, D or 376 or 376A, B, C, D or E or section 509 of IPC is alleged to have been committed or attempted shall be recorded by woman police officer or any woman officer in charge only. That's it. Ninth point, it is specially made to inform that the statement to police under section 161 should not be signed by the accused or the witness. Precisely, subsection 1 of section 162 says, no statement made by any person to a police officer in the course of an investigation under this chapter shall, if reduced in writing, be signed by the person making it. nor shall any statement or any record thereof, whether in police diary or otherwise, or any part of such statement or record be used for the purpose, save herein as provided at any inquiry or trial in respect of any offence under investigation at the time when such statement was made. So the object of section 162 is to impose a ban on the use of a statement made before a police. However, there is a condition. The section further says about it that when any witness is called for prosecution in such inquiry or trial, whose statement has been reduced into writing, that is done under section 161, and any part of his statement, if duly proved, may be used by the accused and with the permission of the court by the prosecution to contradict such witness in manner provided by section 145 of Indian Evidence Act 1872. And when any part of such statement is so used, any part thereof may also be used in re-examination of such witness, but for the purpose only of explaining any matter referred to in his cross-examination. So there is a little liberty used for the statement given to a police. Subsection 2 of section 162 further says, nothing in this section shall be deemed to apply to any statement falling within the provision of subsection 1 of section 32 of Indian Evidence Act 1872, or to give effect to the provisions of section 27 of that act. So when you see section 162, do not forget to quote it with section 145 of Indian Evidence Act along with section 32 and section 27 as well. Now the question comes to the mind that if the statement cannot be used for any purposes, then why such statement is taken? Well, this has been explained very well in a case. Let's take up an important case. Hazari Lal versus the state, that is the Delhi administration, AIR 1980 Supreme Court 873. In this case, it was held that the statement made by witnesses to a police officer in the course of investigation can be used for the purpose of contradicting the witnesses in the manner provided by section 145 of Indian Evidence Act, but it cannot be used as substantive evidence. So this is why the statement should be taken but not to be used against the witness. 10th point, no inducement to be offered under section 163. Subsection 1 of section 163 says, no police officer or person in authority shall offer or make or cause to be offered or made any such inducement, threat or promise. Inducement, threat and promise, they are as mentioned under section 24 of Indian Evidence Act 1872. Police officer we know, so no police officer can do so. But who is the other person in authority that is said under subsection 1 of section 163? Well, this is better explained in a case. Santokhi Beldar versus Emperor, AIR 1933, PAT 149. In this case, it was held that a person in authority is generally one who is engaged in the apprehension, detention or the prosecution of the accused, or one who is empowered to examine him. Next, subsection 2 of section 163 says, but no police officer or other person shall prevent by any caution or otherwise any person from making in the course of any investigation under this chapter any statement which he may be disposed to make of his own free will, provided that nothing in the subsection shall affect the provision of subsection 4 of section 164. This is regarding confession, sign of person confessing and memo of magistrate at foot of such confession. So subsection 1 says shall not ask or force anyone to give statement. Subsection 2 says if a statement is being given by any person, they will not stop him. 11th point. It is recording of confession and statement as per the provision of section 164. Subsection 1 of section 154 says any metropolitan magistrate or a judicial magistrate, which means any judicial officer, whether or not has the jurisdiction in the case, record any confession or statement made to him in the course of an investigation under this chapter or under any law for the time being in force, which means any judicial officer, irrespective of his jurisdiction, he has the power to record any confession or statement. Now there is an important part in it. The magistrate can record any statement, any confession or statement even after the commencement of the inquiry or trial. This is important from judicial point of view, that whether the statement or confession can be recorded by a magistrate even after the trial begins. So yes, it can be as per the provision of subsection 1 of section 164, provided that now there is a condition to subsection 1 of section 164. It says that any confession or statement made under this subsection may also be recorded by audio or video electronic means in the presence of an advocate of the person accused of an offense, which means there is no bar in making a video or recording it. It further says that there is a further condition to it. No confession shall be recorded by a police officer on whom any power of a magistrate has been conferred under any law for the time being in force. Basically, the police has no power under subsection 1 of section 164. The police officer cannot record the confession or a statement of the person accused of an offense. Now let's check what subsection 2 of 164 says. The magistrate shall, before recording any such confession, explain to the person making it that he is not bound to make a confession, and if he does so, it may be used as evidence against him. And the magistrate shall not record any such confession unless, upon questioning the person making it, he has reason to believe that it is being made voluntarily. So there are three things what subsection 2 says. 1. Magistrate will ask the person that you don't need to make any confession, you can change your mind. 2. The magistrate shall inform the accused that, hey, your confession or your statement can be used against you, so think before giving any statement or confession. 3. The magistrate will also note it down that the confession or the statement given by the person is voluntarily. He is not doing under any force, under any pressure or under any fear. Got it? Okay, let's move to subsection 3 of section 164. If any time before the confession is recorded, the person appearing before the magistrate states that he is not willing to make the confession, the magistrate shall not authorize the detention of such person in police custody. Let me inform you that even if the confession is made and recorded, the accused person, as a matter of rule, should not be sent to judicial lockup and on no account be returned to police custody. This means that subsection 3 of section 164 guarantees that the police pressure is not brought on the person who is unwilling to confess. Next is subsection 4 of section 164. It says that any such confession shall be recorded in the manner provided in section 281 of Criminal Procedure Code, obviously, for recording the examination of an accused person, and shall be signed by the person making the confession. It is very obvious. And the magistrate shall make a memorandum at the foot of such record. Now the confession has been made by the person. The procedure is prescribed as per section 281 of Criminal Procedure Code, that how it should be recorded, and it should be definitely signed by the person who is making it. And magistrate is going to, at the foot of the, means at the end of the confession, he is to write, that is called footnote. Let me quickly read the footnote, which the magistrate writes. I have explained to the name of the person who is making a statement or confession, that he is not bound to make a confession, and that if he does so, any confession he may make may be used as evidence against him, and I believe that this confession was voluntarily made. It was taken in my presence and hearing, and was read over to the person making it and admitted by him to be correct, and it contains a full and true account of the statement made by him. So I hope you understand that after the confession of a person is made, this is what the magistrate writes and signs below it. Now we come to subsection 5 of section 164. It says any statement other than the confession made under subsection 1 shall be recorded in such manner thereinafter provided for the recording of evidence as is in the option of the magistrate best fitted to the circumstance of the case, and the magistrate shall have power to administer oath to the person whose statement is so recorded. Now, subsection 5 of section 164 informs us that the magistrate is given specific power to administer oath. Now, this was explained in Aknam Bora versus State of Assam, 1988 Criminal Law Journal 573. In this case, it was held that the confession should be recorded in the manner provided for recording the statement of an accused, and not in the manner provided for recording of evidence by administering an oath. If it is so recorded, it loses its character of a confessional statement insofar as the maker is concerned. This clearly means that the statements are to be recorded under section 274 to 279 according to the circumstance of the case. Now we come to clause A of subsection 5A, which was added later in 2013 of section 164. It says that in cases punishment under section 354, 354A, 354B, 354C and 354D. I'm writing in short form ABCD, but you should not write it in this manner. The section says in cases punishment under section 354, 354A, B, C, D, subsection 1 or subsection 2 of section 376 and section 376A, B, C, D or E or section 509 of IPC. The judicial magistrate shall record the statement of the person against whom such offence has been committed in the manner prescribed in subsection 5, which we already covered just now, as soon as the commission of the offence is brought to the notice of the police. One more important thing to be noted over here. Sometimes in judicial examination, they ask when was this inserted. You should remember that subsection 5A of section 164 was added by Amendment Act of 2013. Even the date can be asked. So do remember with effect from 13/3/2013. There is a condition to subsection A of section 5A. It says if the person making the statement is temporarily or permanently mentally or physically disabled. In this condition, the magistrate shall take the assistance of an interpreter or a special educator in recording the statement of such person. There is a further condition to it, further provided that if the person making the statement is temporarily or permanently mentally or physically disabled, the statement made by the person with the assistance of an interpreter or special educator shall be videographed. It is very clear, I don't need to explain that all such procedures shall be videographed. Now we come to subsection B of section 5A. It says that a statement recorded under clause A of a person who is temporarily or permanently mentally or physically disabled shall be considered a statement in lieu of examination in chief as specified in section 137 of Indian Evidence Act 1872, such that the maker of the statement can be cross-examined on such statement without the need of recording the same at the time of trial. In simple language, it means that the statement of a person who is temporarily or permanently mentally or physically disabled, the statement will be considered as if the statement has been given in the court which is definitely considered as examination in chief, and such things can be cross-examined. Got it? Next is subsection 6 of section 164. The magistrate recording a confession or statement under this section shall forward it to the magistrate by whom the case is to be inquired into or tried. This is applicable in very strict manner and has been explained better in a case of a Shankar Lal versus the state, AIR 1954, ALL 779. The confession or the statement recorded is not made over to the police, means it should not be given to the police, but should be sent directly to the magistrate who is to inquire or try the case. And the failure of the prosecution to send the record to the magistrate is a serious breach of duty, and consequent unavailability of its copy by the accused may violate the trial. So subsection 6 of section 164 says that this procedure is strictly implemented. Now we come to the 12th point, which is medical examination of the victim of rape. That is as per the provision of section 164A. Now, if it is written A in front of a section, this means it has been inserted later on, after the act has been implemented. So this was inserted by amendment of 2005 with effect from 23/6/2006. Let's cover this section. Subsection 1 of 164A says that where during the stage when an offense of committing rape or attempt to commit rape is under investigation, it is proposed to get the person of a woman with whom rape is alleged or attempted to have been committed or attempted be examined by a medical expert. Such examination shall be conducted by registered medical practitioner employed in a hospital run by government or local authority. Now the question comes, if such doctor is not available, which is of the government or local authority, then in absence of such practitioner, any other registered medical practitioner, but this should be with the consent of such woman or a person competent to give such consent on her behalf, and such woman shall be sent to such registered medical practitioner within 24 hours. There is a condition that it should be sent within 24 hours from the time of receiving the information relating to the commission of such offense. Subsection 2 of section 164A says the registered medical practitioner to whom such woman is sent shall without delay examine her person and prepare a report of his examination giving the following particulars. There are 6 particulars. The first one is having 3 things. 1. Name. 2. Address of the woman and the person by whom she was brought. 2. Age of the woman. 3. Description of material taken from the person of woman for DNA profiling. 4. Marks of injury, if any, on the person of woman. 5. Journal mental condition of the woman. And 6th point, other material particulars in reasonable details. It's a simple thing. I don't need to explain. Let's move to the subsection 3 of section 164A. It says the report shall state precisely the reason for each conclusion arrived at. So this is the work of the doctor. Next, subsection 4 of section 164A says a person shall specifically record that the consent of the woman or of the person competent to give such consent on her behalf to such examination has been obtained, means the permission was given by the woman for such medical examination. Subsection 5 of section 164A says the exact time of commencement and completion of the examination shall also be noted in the report. That is, when the report was prepared by the doctor. Subsection 6 of section 164A says the registered medical practitioner, that is the doctor, shall without delay forward the report to the investigating officer who shall forward it to the magistrate as referred in section 173 as part of the documents referred to in clause A of subsection 5 of that section. In simple words, the doctor will hand the report to the investigating officer and that officer will give the report to the magistrate. Now the last point, subsection 7 of section 164A. Nothing in this section shall be construed as rendering lawful any examination without the consent of the woman or of any person competent to give such consent on her behalf. Which means that any procedure which is adopted under this section regarding the examination shall not be done without the consent of the woman. In simple word, it means the woman can refuse for her medical examination. And in explanation clause, it is said that examination and registered medical practitioner shall have the meaning as in section 53. The four important things of section 164A are: 1. The rape has either been committed or attempted. 2. Medical examination of rape victim will be done only if she gives consent to it. 3. Medical examination should be done within 24 hours of its information. I repeat, medical examination should be done within 24 hours of its information, not from the offense of rape, but from the information. So there is a difference between these two. And the fourth point, name and address of her, that is the rape victim, and also of the person who brought her. 13th point, search by police officer as per the provision of section 165. Subsection 1 of section 165 says, whenever an officer in charge of a police station or the police officer making an investigation has a reasonable grounds for believing that anything necessary for the purpose of an investigation into an offense which he is authorized to investigate may be found in any place within the limits of the police station of which he is in charge or to which he is attached, and that such thing cannot in his opinion be otherwise obtained without due delay. Such officer may, after recording in writing the grounds of his belief and specifying in such writing so far as possible the things for which search is to be made, search or cause search to be made for such thing in any place within the limits of such police station. So subsection 1 of section 165 says that the police has the power to search things and will give it in writing the reasons for such search to be done within the limits of such police station. Subsection 2 of section 165 says a police officer proceeding under subsection 1 for a search of a thing, right? It says in subsection 2 that if practicable, conduct the search in person. It simply means that the police officer will conduct the search himself. Subsection 3 of section 165. It says that if he is unable to conduct the search in person and there is no other person competent to make the search present at the time, he may, after recording and writing his reasons for doing so, require any officer subordinate to him to make the search, and he shall deliver to such subordinate officer an order in writing specifying the place to be searched and so far as possible the thing for which search is to be made, and such subordinate officer may thereupon search for such thing in such place. It's a very simple thing. Subsection 3 of 165 says if police officer is not able to conduct the search himself, he will give his reasons in writing and ask his subordinate to conduct the search. And definitely, when he is asking his subordinate, he will give him in writing the place where the search is to be conducted, and then obviously the subordinate will do the search. Subsection 4 of section 165. The provision of as to search warrants and the general provision as to searches in section 100 shall so far as may be apply to search made under this section. So basically the conditions of the search which is explained under section 100 will be implemented. This means that subsection 165 will be read with section 100. Next is subsection 5 of section 165. The copies of any record made under subsection 1 or under subsection 3 shall forthwith be sent to the nearest magistrate empowered to take cognizance of the offence, and the owner or occupier of the place searched shall on application be furnished free of cost with a copy of the same by the magistrate. It simply says the list prepared of the articles found in search will be given to the magistrate and shall be provided free of cost to the owner or occupier of that place. Simple. That's it. So what do we understand by section 165? That it authorizes a police officer to make a search without warrant. It prescribes certain preconditions which must be fulfilled before the search is made. These conditions are that the search is necessary for investigation, that the police is authorized for such investigation, means it must be a cognizable offense, that reasonable ground exists believing that the thing required will be found in a place. Although the conditions are given under section 165, but these are not strict conditions. In state Maharashtra versus MD Soni, AIR 1980 Supreme Court 593, it was held that seizure and consequent trial in respect of such seizure is not violate under this section, even if the search is illegal. Means the illegality of the search will not affect its validity. 14th point. When officer in charge of police station may require another to issue such warrant, as per the provision of section 166. Subsection 1 of section 166 says, an officer in charge of a police station or a police officer not below the rank of sub-inspector, when he is making an investigation, may require an officer in charge of another police station, whether in same or different district, to cause a search to be made in any place, in any case in which the former officer might cause such search to be made within the limits of his own station. We covered section 165. It was search by police officer within his jurisdiction. Now in section 166, the search which can be conducted in the jurisdiction of other police station. In the same manner, subsection 2 of 166 says, such officer on being so required shall proceed according to the provision of section 165 and shall forward the thing found, if any, to the officer to whose request the search was made. So subsection 1 of section 166 says the search in jurisdiction of other police station or other state can be done, and when such search is done, subsection 2 says the things found shall be forwarded to the police who requested to make such search. Simple. Subsection 3 of section 166. It says whenever there is a reason to believe that the delay occasioned by requiring an officer in charge of another police station to cause a search to be made under subsection 1 of section 166 might result in evidence of the commission of an offense being concealed or destroyed, it shall be lawful for an officer in charge of police station or of police officer making an investigation under this chapter to search or cause to be searched any place in the limits of another police station in accordance with the provision of section 165, as if such place were within the limits of his own police station. So subsection 3 of section 166 gives power to the police to search a place even if it is not within his jurisdiction. From judicial examination point of view, this is very important to learn that it is not section 165 which gives power to the police to search outside his jurisdiction. It is subsection 3 of section 166 which gives power to the police to search a place which is not even in his jurisdiction, and the reason should be that the evidence might get concealed or destroyed. Subsection 4 of section 166. Any officer conducting a search under subsection 3 shall forthwith send notice of the search to the officer in charge of the police station within the limits of which such place is situate, and shall also send with such notice a copy of the list, if any, prepared under section 100, and shall also send to the nearest magistrate empowered to take cognizance of the offense copies of the records referred to in subsection 1 and subsection 3 of section 165. So subsection 4 of section 166 says, when the search is conducted by a police officer of another area, shall send notice of the search to the officer in charge of the police station within the limits of which such place is situate. Definitely, the list which is prepared of the things found will also be given, and all such things will be forwarded to the magistrate of that area. Simple. Subsection 5 of section 166. The owner or occupier of the place searched shall on application be furnished free of cost with a copy of any record sent to the magistrate under subsection 4. We already read this in section 165, that copy of the list prepared by the police of things found in the place will be given to the owner or the occupier of the place free of cost. The conclusion of section 166 is that this section authorizes police officer to search a place which is not under his jurisdiction. 15th point. Letter of request to competent authority for investigation in a country or place outside India as per the provision of section 166A. So this was added later on. Let's quickly cover it. Subsection 1 of section 166A says, notwithstanding anything contained in this code, if in the course of an investigation of an offense, an application is made by the investigating officer or any officer superior in rank to the investigating officer, that the evidence may be available in a country or place outside India. So one thing you will note over here is, in previous section we read that an officer in charge of a police station or his subordinate, but the difference over here is that an investigating officer or any officer superior in the rank of investigating officer can make an application. So this is the difference, and do not forget the difference. It further says, any criminal court may issue a letter of request to a court or an authority in that country or place competent to deal with such request. Now the second difference is that for such search, only a criminal court can give authority. Further it says that such a request will be to examine orally any person supposed to be acquainted with the facts and circumstances of the case, and to record his statement made in the course of such examination, and also to require such person or any other person to produce any document or thing which may be in his possession pertaining to the case, and to forward all the evidences so taken or collected, or the authenticated copies thereof, or the things so collected, to the court issuing such a letter. Definitely, as we have already covered, that search will be made and things collected will be given to the court. Subsection 2 of section 166A. The letter of request shall be transmitted in such manner as the central government may specify in this behalf. So the procedure is given by the central government. This is what subsection 2 is informing us. Subsection 3 of 166A. Every statement recorded or document or thing received under subsection 1 shall be deemed to be the evidence collected during the course of investigation under this chapter. Simple, needs no explanation. Let's quickly revise the differences. Section 165. It gives power to the police to search any place without warrant because it is within their jurisdiction. Section 166. It gives power to the police to search any place with warrant because it is outside their jurisdiction. Section 166A gives power to the police to search any place outside India. 16th point. Letter of request from a country or place outside India to a court or an authority for investigation. As per the provision of section 166B, this is regarding the police or other authorities of the country outside India having power to investigate a person in India. Just as in section 166A, the police authorities of India having the power to search a person or a place outside India. Subsection 1 of section 166B says, Upon receipt of a letter of request from a country or authority in a country or a place outside India, competent to issue such letter in that country or place for examination of any person or production of a document or in relation to an offence under investigation in that country or place, the central government may, if thinks fit. Clause I of subsection 1 of section 166B says, forward the same to the Chief Metropolitan Magistrate or CGM of such Metropolitan Magistrate or Judicial Magistrate as he may appoint in this behalf, who shall thereupon summon the person before him and record his statement or cause the document or thing to be produced. Or clause 2 of subsection 1 of section 166B says, send the letter to any police officer for investigation, who shall thereupon investigate into the offence in the same manner as if the offence has been committed within India. Subsection 2 of section 166B says, all the evidence taken or collected under subsection 1 or authenticated copies thereof or the things so collected shall be forwarded by the magistrate or police officer, as the case may be, to the central government for transmitting to the case or authority issuing the letter of request in such manner as the central government may deem fit. So section 166B says, the authority of other country can issue a letter which shall be given to the Indian authorities, which may be, as the government may decide, either a Chief Metropolitan Magistrate or CGM in other case, or even a judicial officer will take appropriate action. They can either summon the person, record his statement, or send the letter received from a foreign country to a police officer for such investigation. And subsection 2 informs us that all the evidence which has been taken or collected, either by the police or the magistrate, will be given to the central government of India, and the central government will send the evidence which has been collected by the police or the magistrate to the country who has requested for the same. That's it. Point 17. Procedure when investigation cannot be completed in 24 hours. This is as per the provision of section 167. Subsection 1 of section 167 says, whenever any person is arrested or detained in custody, this is police custody, and it appears that the investigation cannot be completed within the period of 24 hours fixed by section 57, and there are grounds for believing that the acquisition or information is well founded, the officer in charge of the police station or the officer making the investigation, if he is not below the rank of sub-inspector, shall forthwith transmit to the nearest judicial magistrate a copy of the entries in the diary hereinafter prescribed relating to the case, and shall at the same time forward the accused to the magistrate. Subsection 1 of section 167 is simply informing us regarding a person who is in police custody. When the investigation cannot be completed within 24 hours, the time limit of 24 hours is given under section 57. And it seems that there are no ground to detain him, may send him to the judicial magistrate with copies of entries in the diary relating to the case. Subsection 2 of section 167, it says the magistrate to whom an accused person is forwarded under this section may, whether he has or not jurisdiction to try the case from time to time, authorized the detention of the accused in such custody as such magistrate thinks fit, for a term not exceeding 15 days in whole. This means subsection 2 of section 167 is informing us the power of the magistrate to detain a person accused in an offence for a further period which may be extended maximum up to 15 days in whole, which means he can either say that detain the person for another 3 days or detain the person for another 5 days, but in total it should not exceed 15 days in whole. It further says, and if he has no jurisdiction to try the case or commit it for trial and consider further detention unnecessary, he may order the accused to be forwarded to a magistrate having such jurisdiction. So the second part of subsection 2 of section 167 is informing us that if he has no jurisdiction to detain the person, he may forward the case to the magistrate who has the jurisdiction. Subsection 2 of section 167 has a condition. It says, provided that A, The magistrate may authorize the detention of the accused person otherwise than in police custody beyond a period of 15 days if it is satisfied that adequate grounds exist for doing so, but no magistrate shall authorize the detention of the accused person in custody under this paragraph for a total period exceeding 90 days where the investigation relates to the offense punishable with death, imprisonment for life, or imprisonment for a term not less than 10 years. So the condition to subsection 2 of section 167 is that the period of 15 days which was mentioned can be amended and it can be extended but not more than 90 days if the offense committed by the accused person relates to the offense punishable with death, imprisonment, or a punishment for not less than 10 years. These are the three conditions. It further says that the period of extension of his detention may be up to 60 days when investigation relates to the other offenses and on the expiry of the period of 90 days or 60 days as the case may be. The accused person shall be released on bail if he is prepared to and does furnish bail. And every person released on bail under this subsection shall be deemed to be so released under the provision of Chapter 33 for the purposes of that chapter. So the second condition to subsection 2 of section 167 is that the period of detention may be extended up to 60 days in other offenses or 90 days if the offense is related to an offense which may be punishable with death, imprisonment for life, or 10 years of term. We already covered that. So what to do when such period is also expired? Well, you can release them on bail. Simple. Now clause B comes to the condition of subsection 2 of section 167. It says that no magistrate shall authorize detention of the accused person in custody of the police under this section unless the accused is produced before him in person for the first time and subsequently every time till the accused remains in custody of the police, which means for every extension of detention, the police must bring the accused person before the magistrate. It further says, but the magistrate may extend further detention in judicial custody on production of the accused either in person or through the medium of electronic video linkage. This is a provision where we cannot bring the accused to the court. Well, the things can be done basically through video conference as well. Next is subsection 2 of section 167. It says that no magistrate of the second class not specifically empowered in this behalf by the High Court shall authorize detention in custody of the police. Basically, a magistrate of second class is not authorized for detaining a person in police custody. But in some cases, the powers may be delegated to him. Now let's cover the first explanation. It says that for the avoidance of doubts, it is hereby declared that notwithstanding the expiry of the period specified in paragraph A, the accused shall be detained in custody so long as he does not furnish bail. Well, the period of detention is expired. It may be 90 days or 60 days. And if bail is not given, then unfortunately the person will have to remain in police custody. Explanation 2 says, if any question arises whether an accused person was produced before the magistrate as required under clause B, the production of the accused person may be proved by his signature on the order authorizing detention or by order certified by the magistrate as to production of the accused person through the medium of electronic video linkage as the case may be. Explanation 2 is informing us when the accused person is brought before the magistrate through electronic means, a certificate to that effect will be produced that it was done through electronic mode. That's it. Subsection 2 of section 167 has a further condition. It says that in case of women under 18 years of age, the detention shall be authorized to be in custody of a remand home or recognized social institution. Part 2A of section 167 says, notwithstanding anything contained in subsection 1 or subsection 2, the officer in charge of a police station or the police officer making the investigation, if he is not below the rank of sub-inspector, may, where a judicial magistrate is not available, transmit to the nearest executive magistrate on whom the power of a judicial magistrate or metropolitan magistrate have been conferred a copy of the entry in the diary hereinafter prescribed relating to the case, and shall at the same time forward the accused to such executive magistrate and thereupon such executive magistrate may, for reasons to be recorded in writing, authorize the detention of the accused person in such custody as he may think fit for a term not exceeding 7 days in the aggregate, and on the expiry of the period of detention so authorized, the accused person shall be released on bail except where an order for further detention of the accused person has been made by a magistrate competent to make such order, and where an order for such further detention is made, the period during which the accused person was detained in custody under the orders made by an executive magistrate under this subsection shall be taken into account by computing the period specified in para A of the proviso to subsection 2. Don't be confused. This is further delegation of the power that in case a judicial magistrate is not available, only in that case the accused person will be brought before an executive magistrate. The police cannot take an excuse that judicial magistrate is not available, so we did not bring him to the magistrate. No. If he is not available, that is the judicial magistrate, then the accused person should be brought before an executive magistrate. And it is further informed that executive magistrate has the power to detain the accused person for a period of 7 days, and other things remain the same, that he can be released on bail after the expiry of such period. Now there is a condition to it. Let's cover it. Provided that before the expiry of the period aforesaid, the executive magistrate shall transmit to the nearest judicial magistrate the records of the case together with a copy of the entries and diaries relating to the case, which was transmitted to him by the officer in charge of the police station or the police officer making the investigation, as the case may be. Well, there is a condition to it that before the expiry of the detention of the person which the executive magistrate has ordered, the case can be sent to the judicial magistrate. If the judicial magistrate is available later on, this can be done. Simple. There should not be any confusion. Subsection 3 of Section 167. A magistrate authorizing under this section detention in the custody of the police shall record his reasons for doing so. Well, why the magistrate want the detention of the person? The reasons will be given. This is a simple thing, but the thing to be remembered is the reasons to be recorded is given as per the provision of subsection 3 of section 167. Subsection 4 of section 167. It says any magistrate other than the chief judicial magistrate making such order shall forward a copy of his order with his reasons for making it to the chief judicial magistrate. So subsection 4 of section 167 is simply informing the procedure to be adopted by a magistrate who is junior to CGM, that he is making such order, and the copy will be forwarded to CGM with reasons for making such order. Subsection 5 of section 167. It says if in any case triable by magistrate, a summon case, the investigation is not concluded within a period of 6 months from the date on which the accused was arrested, the magistrate shall make an order stopping further investigation into the offence unless the officer making the investigation satisfies the magistrate that for special reasons and that in the interest of justice, the continuation of the investigation beyond the period of 6 months is necessary. Subsection 5 of section 167 is simply informing us that the magistrate will stop the inquiry in case the inquiry is not concluded within the period of 6 months. In case the inquiry officer wants the extension of detention beyond the period of 6 months, he will have to make special reasons in writing that why the investigation could not have been completed and why it is necessary to keep him detained for a period more than 6 months. Subsection 6 of section 167. Where any order stopping further investigation into an offence has been made under subsection 5, the session judge may, if he is satisfied on application made to him or otherwise that further investigation into the offence ought to be made, vacate the order made under subsection 5 and direct further investigation to be made into the offence subject to such direction with regard to bail and other matters as he may specify. This is in continuation to subsection 5 of section 167. That if the order to stop the investigation has been made under subsection 5 of section 167, The inquiry officer may approach the session judge against the order made under subsection 5 of section 167 that they want to investigate the case further. The session judge may order that investigation can be done. Means the session judge has the power to overrule the order under subsection 5 of section 167. Eighteenth point, report of investigation by subordinate police officer under the provision of section 168. Section 168 is informing us when any subordinate police officer has made any investigation under this chapter, he shall report the result of such investigation to the officer in charge of the police station. So this section is simply informing the procedure of the police when the investigation is done by the subordinate. The report of such investigation will be given to the officer in charge of the police station. One point was raised in a case: can an accused person be allowed to see what the report is prepared by the police under the investigation? Armungam versus State, 1897, 20, Madras. In this case, it was held that a report made by a police officer under this section is not a public document within the meaning of section 74 of the Evidence Act, and therefore an accused person is not entitled before the trial to have copies of this report. So this may be taken as an authority that before the trial he cannot have the copies, but he can assess, he can have the copies of the report only after the trial begins. Nineteenth point, release of an accused when evidence deficient under section 169. Section 169 says, if upon an investigation under this chapter, it appears to the officer in charge of the police station that there is no sufficient evidence or reasonable ground of suspicion to justify the forwarding of the accused to a magistrate, such officer shall, if such person is in custody, release him on his executing a bond, with or without sureties, as the officer may direct, to appear, if and when so required, before a magistrate empowered to take cognizance of an offence on a police report and to try the accused or commit him for trial. So section 169 gives power to police to release a person if arrested on two grounds. 1. There is no sufficient evidence. 2. There is no reasonable ground of suspicion, and the police may also decide to release person with or without sureties. That's it. 20th point, cases to be sent to magistrate when evidence is sufficient as per the provision of section 170. In section 169, we read that if the evidence is deficient, obviously the police has the power to release the person with or without sureties. But now in section 170, it says that if the evidence is sufficient, then the case will be sent to magistrate. Let's cover it in detail. Subsection 1 of section 170 says, if upon an investigation under this chapter, it appears to the officer in charge of the police station that there is sufficient evidence or reasonable ground as aforesaid, such officer shall forward the accused under the custody to a magistrate empowered to take cognizance of the offence upon a police report and to try the accused or commit him for trial. Or, if the offence is bailable and the accused is able to give security, shall take security from him for his appearance before such magistrate on a day fixed, and for his attendance from day to day before such magistrate until otherwise directed. So subsection 1 informs us, if there is sufficient evidence or a reasonable ground, then the accused person will be sent to the magistrate and the case will be initiated against him. Only in case of bailable offense, the bail will be given to the person, but he will have to appear before the magistrate on a given date. That's it. Subsection 2 of Section 170 says, when the officer in charge of a police station forwards an accused person to a magistrate or takes security for his appearance before such magistrate under this section, he shall send to such magistrate any weapon or other article which it may be necessary to produce before him, and shall require the complaint, if any, and so many of the persons who appear to such officer to be acquainted with the facts and circumstances of the case as he may think necessary to execute a bond to appear before the magistrate or thereby directed and prosecute or give evidence as the case may be in the matter of the charge against the accused. Subsection 2 of Section 170 is informing us that when the police either send the accused to the magistrate for further custody, obviously, or give bail on security, they will also send weapon or other article used in the crime and also execute bonds of such person who will give evidence on the charges framed against the accused. Next, subsection 3 of Section 170 says, if the court of the CGM is mentioned in the bond, such court shall be held to include any court to which such magistrate may refer the case for inquiry or trial, provided that a reasonable notice of such reference is given to such complainant or persons. So, subsection 3 is regarding a court procedure that if a court of CGM is mentioned in the bond, it does not necessarily mean only on that court. It includes any court which the magistrate may refer. Obviously, when a CGM court is mentioned in the bond, and if there is any change, a prior notice to be given to the complainant or the persons. Simple. That's it. And now the last point, subsection 4 of Section 170. It says the officer in whose presence the bond is executed shall deliver a copy thereof to one of the persons who executed it, and shall then send to the magistrate the original with his report. Again, it's a simple procedure of the bond. One copy will be given to the person who has signed it, and other will be sent to the magistrate. All you need to remember is that subsection 4 is informing us that the copy is given to one of the person who executed it, and the original will be sent to the magistrate with the report of the police. Next point, complainant and witnesses not to be required to accompany police officer and not to be subjected to restraint as per the provision of Section 171. Section 171 says, no complainant or witness on his way to court shall be required to accompany a police officer, or shall be subjected to unnecessary restraint or inconvenience, or required to give any security for his appearance other than his own bond, provided that if any complainant or witness refuses to attend or to execute a bond as directed in Section 170, the officer in charge of the police station may forward him in custody to the magistrate, who may detain him in custody until he executes such bond or until the hearing of the case is completed. So what do we understand by Section 171? Well, it says that if a police officer detains any witness against his will, his act will be illegal, for which he may be liable to punishment, and also that any statement obtained from a witness by subjecting him to restraint cannot be regarded as voluntary. The second point of Chapter 12, Diary of Proceedings in Investigation, as per the provision of Section 172. Subsection 1 of Section 172 says, every police officer making an investigation under this chapter shall day by day enter his proceedings in the investigation in a diary, setting forth the time at which the information reached him, the time at which he began and closed his investigation, place and places visited by him, and a statement of circumstances ascertained through his investigation. Subsection 1A of Section 172, this was added in the amendment of 2009. The statement of witnesses recorded during the course of investigation under Section 161 shall be inserted in the case diary. And subsection 1B of Section 172 says, the statement of witnesses recorded during the course of investigation under Section 161 shall be inserted in the case diary. And subsection 1A of Section 172 says, the statement of witnesses recorded during the course of investigation under Section 161 shall be inserted in the case diary. And subsection 1B The diary referred to in subsection 1 shall be a volume and duly paginated. This means that the police diary contains a statement of witnesses and every page will be numbered so that the things are in serial order. Subsection 2 of section 172 says any criminal court may send for the police diaries of a case under inquiry or trial in such court and may use such diaries not as evidence in the case but to aid it in such inquiry or trial. Subsection 3 of section 172 says neither the accused nor his agents shall be entitled to call for such diaries, nor shall he or they be entitled to see them merely because they are referred to by the court. But if they are used by the police officer who made them to refresh his memory, or if the court uses them for the purposes of contradicting such police officer, the provisions of section 161 or section 145 as the case may be of the Indian Evidence Act shall apply. The object of the section is to enable the magistrate to know what was the day-to-day information by the police officer who was investigating the case and what were the lines of his investigation. In Puri Mohandas versus D. Western, 1911, 16 CWN 145. In this case, it was held that the object of maintaining a case diary is to enable the court to check the method of investigation by the police. Point 23. Report of police officer on completion of investigation as per the provision of section 173. Subsection 1 of section 173 says, every investigation under this chapter shall be completed without unnecessary delay. Well, we say this, but practically it doesn't happen. But nowadays it does happen as well. So the equation is all. It happens and it doesn't happen. Anyway, subsection 1A was added in 2009 that the investigation in relation to rape of a child may be completed within 3 months from the date on which the information was recorded by the officer in charge of the police station. So the time limit is framed in relation to an offense of rape on a child within 3 months. But it is not strictly 3 months as it says may be completed within 3 months. Next, subsection 1 of subsection 2 of section 173, it says as soon as it is completed, the officer in charge of the police station shall forward to a magistrate empowered to take cognizance of the offense on a police report, a report in the form prescribed by the state government stating A. Name of the parties, B. The nature of the information, C. The name of the persons who appear to be acquainted with the circumstances of the case, D. Whether any offense appears to have been committed and if so, by whom, E. Whether the accused has been arrested, F. Whether he has been released on his bond and if so, whether with or without sureties, G. Whether he has been forwarded in custody under section 170. H. It was added in 2009 whether the report of medical examination of a woman has been attached where investigation related to offences under section 376, 376A to D or section 376E of Indian Penal Code. Clause 2 of subsection 2 of section 173, it says the officer shall also communicate in such manner as may be prescribed by the state government the action taken by him to the person, if any, by whom the information relating to the commission of the offence was first given. So subsection 1 of section 173 says the report should be prepared without any unnecessary delay. Subsection 1A says the report on the child should be completed within 3 months. And clause 1 of subsection 2 of section 173 says that the report of police should be filled in prescribed form. The report shall also include that what action was taken by the person to whom the offence was first given. Subsection 3 of section 173. It says where a superior officer of police has been appointed under section 158, the report shall in any case in which the state government by general or specific orders so directs be submitted through that officer, and if he may, pending the orders of the magistrate, direct the officer in charge of the police station to make further investigation. So subsection 3 is simply informing us that in case the work superior officer is appointed in regard to an offense, the report will be submitted by him until and unless he has deputed the same work to his subordinate. Subsection 4 of Section 173. It says whenever it appears from a report forwarded under this section that the accused has been released on his bond, the magistrate shall make such order for the discharge of such bond or otherwise as he thinks fit. So subsection 4 of section 173 says if it appears from the report that the person has been released on bond, so it is going to be on the magistrate whether to discharge or not to discharge such person on bond. Subsection 5 of section 173. When such report is in respect of a case in which section 170 applies, the police officer shall forward to the magistrate along with the report A. all documents or relevant extracts thereof on which the prosecution processes to reply other than those already sent to the magistrate during investigation. B. the statements recorded under section 161 of all persons whom the prosecution proposes to examine as its witnesses. So subsection 5 is simply informing us that on completion of a report of a police officer, all such documents during the investigation or the statement of the persons taken will be forwarded to the magistrate. Subsection 6 of section 173. It says if the police officer is of opinion that any part of any such statement is not relevant to the subject matter of the proceedings, or that its disclosure to the accused is not essential in the interest of justice and is inexpedient in the public interest, he shall indicate that part of the statement and append a note requesting the magistrate to exclude that part from the copies to be granted to the accused and stating his reasons for making such request. Subsection 6 of section 173 informs us that the police officer can make a request to the magistrate. Two things. 1. To remove such part of statement which is not relevant to the subject matter. 2. In the interest of justice, remove some part from the copies to be granted to the accused. But the police officer has to state his reasons for making such a request. Subsection 7 of section 173. It says where the police officer investigating the case finds it convenient so to do, he may furnish to the accused copy of all or any of the documents referred to in subsection 5. So subsection 7 of section 173 says that police officer will provide copies to the accused person, but subject to the provision of subsection 5 of section 173. Subsection 8 of section 173 says nothing in this section shall be deemed to preclude further investigation in respect of an offence after a report under subsection 2 has been forwarded to the magistrate, and where upon such investigation the officer in charge of the police station obtains further evidence, oral or documentary, he shall forward to the magistrate a further report or reports regarding such evidence in the form prescribed, and the provisions of subsection 2 to subsection 6 shall, as far as may be, apply in relation to such a report or reports as they apply in relation to a report forwarded under subsection 2. So it is subsection 8 of section 173 which informs us that once the report has been forwarded to the magistrate under subsection 2 of section 173, it does not mean that no further investigation can be done. The officer in charge of the police station can further take evidence, oral or documentary, and he shall forward the same to the magistrate. A further report or reports. That's it. So what do we understand by section 173? The report submitted under this section, that is section 173, is called completion report or charge sheet. In Rama Shankar vs. State of UP, AIR 1956, Allahabad, ALL 525. In this case, it was held that submission of charge sheet means that the preliminary investigation and preparation of the case is over and the magistrate can take cognizance of the offence. Let's take up another important case. In Hassan Bhai, Wali Bhai Qureshi or H.V. Qureshi vs. State of Gujarat, 2004 Criminal Law Journal, 2018 Supreme Court. In this case, it was held that even after the court take cognizance of offence on earlier report submitted by police, it is open to police to conduct further investigation in a proper manner. If fresh facts come to light, police should seek permission of court for further investigation. It is also made clear that further investigation should not be ruled out merely on grounds that it may delay trial. So in this case, it was held that the police should seek permission of the court for further investigation, and further investigation can be done. Point 24. Police to inquire and report on suicide, etc. Now the point etc. says it is going to inquire and report not only on suicide but in other death cases as well. Subsection 1 of Section 174 says, when the officer in charge of a police station or some other police officer specially empowered by the state government in this behalf receives information that a person has committed suicide or has been killed by another, or by an animal, or by machinery, or by an accident, or has died under circumstances raising a reasonable suspicion that some other person has committed an offence, he shall immediately give information thereof to the nearest executive magistrate empowered to hold inquests, and unless otherwise directed by any rule prescribed by the state government or by journal or specific order of the district or subdivisional magistrate, shall proceed to the place where the body of such deceased person is, and there in the presence of two or more respectable inhabitants of the neighborhood shall make an investigation and draw up a report of the apparent cause of death, describing such wounds, fractures, bruises, and other marks of injury as may be found on the body, and stating in what manner or by what weapon or instrument, if any, such marks appear to have been inflicted. It simply means that Section 174 is providing information cases of unnatural deaths and death under suspicious circumstances. Subsection 2 of Section 174. It says the report shall be signed by such police officer and other persons, or by so many of them as concur therein, and shall be forthwith forwarded to the district magistrate or the subdivisional magistrate. The report prepared by the police into a suicide case or unnatural death cases, as per the provision of subsection 1 of Section 174, it will be signed by the police officers and other persons who are available over there, and such report shall be forwarded to the district magistrate or subdivisional magistrate as the case may be. Subsection 3 of Section 174. It says when clause 1 of subsection 3 of 174, the case involves suicide by woman within 7 years of her marriage, or the case relates to the death of a woman within 7 years of her marriage in any circumstances raising reasonable suspicion that some other person committed an offence in relation to such woman, or the case relates to the death of a woman within 7 years of her marriage and any relative of the woman has made a request in this behalf, or there is any doubt regarding the cause of death, or the police officer for any reason consider it expedient so to do, he shall, subject to such rules as the state government may prescribe in this behalf, forward the body with a view to its being examined to the nearest civil surgeon or other qualified medical man appointed in this behalf by the state government, if the state of the weather and the distance admit of its being so forwarded without risk of such putrefaction on the road as would render such examination useless. Putrefaction means decomposition of the body. The important thing in subsection 3 of Section 174 is the death of a woman within 7 years of her marriage will be considered a cause of suspicion, and the body will be sent to civil surgeon or other medical person for examination without the risk of the body being decomposed. Subsection 4 of Section 174. The following magistrate are empowered to hold inquests, namely any district magistrate or subdivisional magistrate and any executive magistrate, which is specially empowered in this behalf by the state government or the district magistrate. Now let's cover some important cases relating to Section 174. In Palani Swami vs. State, AIR 1968, BOM Bombay 127, it was held in this case, ordinary accused is not entitled to copies of statement recorded, but in the interest of fair trial, requires that they should be made available to the accused at appropriate time. And in Razak Ram vs. J.S. Chauhan, AIR 1975, Supreme Court 667. Also AIR 1959, Supreme Court 1012. It was held that the statement made under Section 174 cannot be used as a substantive piece of evidence. At the most, it can be used only as a previous statement to corroborate or contradict the person making it at the trial. 25th point. Power to summon persons as per the provision of Section 175. Subsection 1 of Section 175 says a police officer proceeding under Section 174 may by order in writing summon two or more persons as aforesaid for the purpose of the said investigation, and any other person who appears to be acquainted with the facts of the case, and every person so summoned shall be bound to attend and to answer truly all questions other than questions the answers to which have a tendency to expose them to a criminal charge or to a penalty or forfeiture. This section, Section 175, authorizes a police officer to summon in connection with the investigation those persons who appear to be acquainted with the facts of the case. It also says that it is not necessary that all eyewitnesses should be examined at an inquest. Inquest is Panchnama. The second most important fact of Section 175 is that all persons summoned under this section shall be bound to answer all questions truly. The refusal to answer the question is punishable under Section 179 of the Indian Penal Code. Subsection 2 of Section 175 says, if the facts do not disclose a cognizable offence to which Section 170 applies, such persons shall not be required by the police to attend a magistrate's court. This means that the police will not ask such person to give evidence in a court as a witness, if it does not become to be a cognizable offence. Now we come to the last point, point number 26. Inquiry by magistrate into cause of death, which means this is not by the police officer, as per the provision of Section 176. Subsection 1 of Section 176 says, when the case is of the nature referred to in Clause 1 or Clause 2 of Subsection 3 of Section 174, the nearest magistrate empowered to hold inquest shall, and in any other case mentioned in Subsection 1 of Section 174, any magistrate so empowered may hold an inquiry into the cause of death either insisted of or in addition to the investigation held by the police officer. And if he does so, he shall have all the powers in conducting it which he would have to hold an inquiry into an offence. Section 1A says, where A. any person dies or disappears, or B. rape is alleged to have been committed on any woman, while such person or woman is in custody of the police or in any other custody authorized by the magistrate or the court. Under this code, in addition to the inquiry or investigation held by the police, an inquiry shall be held by the judicial magistrate or the metropolitan magistrate, as the case may be, within whose local jurisdiction the offence has been committed. Subsection 2 of Section 176. The magistrate holding such an inquiry shall record the evidence taken by him in connection therewith in any manner hereinafter prescribed according to the circumstances of the case. Subsection 3 of Section 176 says, whenever such magistrate considers it expedient to make an examination of the dead body of any person who has already entered in order to discover the cause of his death, the magistrate may cause the body to be disinterred and examined. Interred means a corpse, that is the dead body, in a grave or a tomb. And disinterred means to bring out the dead body out of the grave. We'll explain in details later on. Next, subsection 4 of Section 176, it says, where an inquiry is to be held under this section, the magistrate shall, wherever practicable, inform the relatives of the deceased whose name and addresses are known and shall allow them to remain present at the inquiry. Subsection 5. This was inserted in the Amendment Act of 2005. The judicial magistrate or the metropolitan magistrate or executive magistrate or the police officer holding an inquiry or investigation, as the case may be, under subsection 1A, shall within 24 hours of the death of a person forward the body with a view of its being examined to the nearest civil surgeon or other qualified medical man appointed in this behalf by the state government, unless it is not possible to do so for reasons to be recorded in writing. The explanation part of 176 says, in this section, the expression relative means parents, children, brothers, sisters, and spouse. So basically, the proceedings under this section, that is section 176, are judicial proceedings, and the High Court exercise its jurisdiction under section 397 and 401 or under 482 of this code. In chapter 12 up to section 175, we have read the power of the police to investigate, but one section, that is section 176, this is the power of the magistrate to inquiry into the cause of death. What was the purpose of this section in the chapter 12? It was explained in P. Rajangam versus State of Madras, AIR 1959, Madras 291. It was held that this section is designated to provide a check on the inquiry held by the police or to calm any alarm that has been created in the mind of the public by reason of violent or unnatural death. The important ingredients or the elements of section 176 are: 1. Section 176 is power of magistrate to inquiry into cause of death, disappearance of a person, or a rape has been alleged on a woman while such person or a woman is in police custody. 2. CGM or metropolitan magistrate can hold inquiry even if the inquiry or investigation has already been done by the police. 3. Power of magistrate to disinter a body to discover the cause of death, which is to bring out the body out of the grave. With this, we come to the end of a huge chapter. Revise it, repeat it while traveling or waiting for someone, so that in your free time you can learn this by heart.